Good afternoon, everyone. This is Matt Kinsman, Head of Content at Connectiv. Thanks again for joining us today for GDPR Primer Part 2. The deadline for complying with the General Data Protection Regulation is May 25th. That's right around the corner, particularly considering how much the GDPR leaves open to interpretation. Some of you joining us today also attended the excellent first part of this webinar series on GDPR that SIIA Senior Director of International Public Policy, Carl Schonander, gave in October. Today, Carl will be offering an update on actions that companies can take to prepare for GDPR, as well as share compliance resources that you can also use as a part of your efforts. As a reminder, you can submit questions via the chat tab in the lower left-hand corner of your screen at any time during the presentation, and we'll also hold a Q&A at the end. Carl, take it away.
Thank you very much, Matt. Really appreciate that. Good afternoon to everybody. As Matt said, May 25 is around the corner. One logistical thing, I will do a Q&A at the end of this, and if I see questions, maybe address them during the presentation as well. My email address is available on the first slide and telephone number. So if anybody is interested in follow-up or anything, just shoot me an email or phone me. So here are the goals for this presentation. I'll very quickly provide you links and information on previous SIIA resources presentations that we've done. I will provide links and names of resources and guidance that have emerged since the last presentation I did, which was actually on December 19, 2017, and you can have access to that presentation as well. I will try to focus in this presentation on online B2B marketing issues because I think, correct me if I'm wrong, I think that many participants in this webinar are interested in those issues. I'll highlight the General Data Protection Regulations, Article 30, record of processing of just one way of organizing your GDPR compliance work. Just one quick note on that. You're not obliged to do a record of processing if you have 250 employees or less, but I think it's sort of a good way of organizing your work. And then I'll try to provide a sense for what Data Protection Authority enforcement priorities might be after the General Data Protection Regulation enters into force on May 25. There will be some slides that are familiar to those of you who were on my first webinar, but I'm not going to focus on them so much today, but they're available to you all as a resource. So just very quickly, a refresher a little bit on history and key provisions, so we can all start from the same level of knowledge. So proposal for a GDPR back in 2012, agreement between the European Council and Parliament on December 15, 2015. Final text of the General Data Protection Regulation published in April 2016. The link here says final text. That's quite good because if you link to it, you get a page with each individual article and also the recitals that go with each article. So it's not a bad thing. Excuse me, you'd have to go to the DSB MIT system presentation for that. So key changes, increased territorial scope. You don't have to have an office in the EU in order for the General Data Protection Regulation to apply to you. Higher penalties, everybody's aware of that. Your consent language has to be written more clearly. There's a 72-hour breach notification requirement. Customers have a right to access. There's the famous right to be forgotten. That's a lot has been written about that. Excuse me. There's a data portability requirement. privacy by design, data protection officers as well. You don't necessarily, I think there's been a little bit of misunderstanding about that. I think there are two things to remember about the data protection officer requirement. First is, if you decide you want to have a data protection officer, it doesn't have to be a new headcount. It can be somebody in your organization who fulfills the role of data protection officer, but he or she does have to have some knowledge of the topic and be logically placed to handle the role. When it comes to the DPO requirement for companies, it really only applies to companies that have processing operations that require systematic monitoring of data subjects. So, if you're collecting sort of basic B2B address information, but you're not actually monitoring what your customers are doing, you probably don't need, if you don't want to have it, you probably don't need to have a data protection officer, but it is something to think about. And Articles 37 to 39 go into that topic. I mention it because I've gotten a lot of questions about it, and there are a lot of people who are concerned about that requirement. So again, increased territorial scope of the general data protection regulation. You don't have to have an office for it to be applicable to you. Here's the definition of personal data. Personal data means any information relating to an identified or identifiable natural person. And again, something that's of great interest to at least the majority of people in this audience is that excuse me, I lost my train of thought there. I'll take a question now from Stuart Bonner, who says, I read in a couple of places that the GDPR compliance picture might look slightly different, i.e. more lenient for companies with less than 250 employees. True, false? Well, remember at the beginning of this presentation, I mentioned the record of processing document that companies with over 250 employees are supposed to have. So to the extent that you have fewer than 250 employees, you don't have to produce that document. Having said that, though, I would say that it's useful for anybody involved in data protection to look at Article 30 and see what you need to have in order to have a record of processing. And one thing that's, that a lot of people haven't really understood completely is that a record of processing doesn't necessarily have to be a very complicated document, and it's not the same thing as a data inventory. Basically, what it asks for is, the contact, who is the data controller, who are your contact people, what type of data you hold, but not exactly each data element which you would have to have in a data inventory. And it also importantly asks you for what transfer mechanism do you use to transfer personally identifiable information if you transfer it from outside the European Union. So for example, if you process your data in the United States, then you have to have some form of transfer mechanism. And we've talked in the past about the EU-US Privacy Shield. That's a good one. There's over 2,500 companies that are already signed up to that. There are other mechanisms too, but you have to have some form of mechanism. So to answer Stuart's question, it's true that the compliance picture is slightly different, i.e. more lenient, but wouldn't say it's that much more lenient. Again, even if you don't have an office in an EU country, if you offer services in the Union, you're subject to the General Data Protection Regulation. If you happen to offer a service to a German residing in the United States, you're not subject to GDPR. A couple of questions that are worth asking as you think through. Do you offer goods and services to individuals? Do you monitor the behavior of individuals? Do you have employees in the European Union? HR data is something that is handled in a particular way, always has been, even under the Data Protection Directive. So all of these things are worthwhile thinking about. You have to figure out if you're a data controller or a data processor. I think most of you are probably data controllers. So then I did a presentation in December, and I got a lot of questions from companies who sort of asked me, I'm going to take Bill McDowell's question. Can you clarify the second bullet on the previous slide about serving EU citizens outside the EU? Yes. So what I meant by that was that if you have an EU client who is residing outside the European Union, that doesn't make you subject to the General Data Protection Regulation. The requirement is that the individual has to actually be in the Union. I hope that answers Bill's question. So I got a lot of questions from legal officers in different companies who sort of said to me, well, okay, yes, we provide services to EU citizens, but we don't have an office in the European Union. So why should I care about this? And the premise behind the question is, well, it would be very difficult for the European Union to impose the 4% fine that everybody is fixated on. Here's the thing. Even if you do not have an office in the EU, if you process personal data from the EU, you are supposed to have a representative in the EU. Now, you could ask, well, if I don't have a representative, how am I going to be served? How is anybody going to come after me? The thing to take a look at is there are some other powers that European data protection authorities have besides the fine power. They're listed in Article 58 of the General Data Protection Regulation. And those are powers of being able to investigate, even stop data flowing from one entity to another. So there are other things besides imposing fines that data protection authorities can do. But I think actually the largest reason why the majority of you have to care about this is because many of your larger business partners are going to require that you be GDPR compliant. And you might have contracts with those business partners that are actually drawn up in the United States. So I heard this from several companies when I did a presentation in December. I think that is going to become, over time, the biggest driver in all of this. What kind of level of resources should you devote to the General Data Protection Regulation? It depends on a lot of different factors. How sensitive is the data that you hold? Health data is not the same thing as business contact information, which again I think is personal. A business contact's email address is personal, even though data about the company that that person works for is not personal. Do you sell the data you collect? Do you use the data for ad targeting purposes? Do you transfer data outside of the European Union? Do you monitor individuals? Children is always a big sensitive issue. A couple of resources, if you want to go back in addition to this slide deck that will be made available to all of you after this presentation. There's a December 19 presentation which is focused on which companies are subject to the General Data Protection Regulation, what the risks and opportunities are, resources available to firms. There's the October 3, 2017 webinar we did. And then this presentation, which is actually now a year and a half old, but I think actually still very important to those of you who transfer personally identifiable information from the European Union to the United States. What transfer mechanism do you use in order to do that? I mention this because European regulators are somewhat fixated on this. So this webinar tells you what you need to do in order to certify under the EU-US Privacy Shield. There are other mechanisms that you can use, such as binding corporate rules and standard contractual clauses. They tend to be much more expensive. It's much cheaper to certify under the Privacy Shield. You still have to do quite a bit of work, but it is cheaper. So I mentioned that, and if anybody has any questions about this particular issue, of course, let me know.
Excuse me, Carl, one question that did come in. With regard to the point on children, are we required to obtain age in addition to consent?
Well, you have to know what the age of the child is, and the rule is this. The general rule is that for children 16 or younger, you need to have parental consent. However, member states have flexibility to reduce that to 13. So not only do you have to follow the general rule, but you have to know what the rule is in the individual member state. So this is something that's worth thinking about. Even though the whole purpose of the General Data Protection Regulation is to have uniform rules throughout the European Union, there are some areas where member states are allowed to have different rules. And here are some of the resources from previous presentations. And if you scroll further through this presentation, you'll find the information on what the British Information Commissioner Office is doing. And I always mention them for a couple of different reasons. One is they do stuff in English. Two is they're quite helpful. And they actually have a new service, which I haven't tried yet, but I will try because I think it'll be interesting to see how responsive they are. They have an online advice service for small organizations, and I've provided you all on this slide with the telephone number. So 0303-123-1113, option 4 to staff. You're supposed to get a live human being if you need it. So that is something I would check out. There's also the Bavarian Data Protection Authority questionnaire, and the reason why I mentioned that is I've attended, as part of becoming GDPR wise, I try to sign up for as many webinars and presentations as possible, and a lot of people are talking about the Bavarian Data Protection Authority questionnaire as sort of a model for what data protection authorities might be looking for. So take a look at that. That's in English. TrustArc's Essential Guide to the General Data Protection Regulation is quite good. Global Strategy. There's IIPP. Over here I put mention Privacy Shield again. There are a lot more resources. I'm not trying to necessarily steer people to these. these seem to me to be sort of among the best that I've seen. But you know, as I said, there are a lot of different resources. So in preparation for this webinar, of course, I tried to look for new resources, and there are some things. There really is a GDPR preparation frenzy going on. And by the way, I forgot to mention at the beginning of this presentation, I noticed yesterday's New York Times has a fairly large piece about general data protection regulation compliance efforts, you know, with interviews with major U.S. technology companies. So I commend that article to people. It's kind of interesting background. So the European Commission just launched a new website to provide information. They're focused on providing information that's useful, especially to smaller companies. It's worthwhile clicking on that particular link to figure out what the Commission's priorities are. This link is quite interesting because it provides a sort of list of things that companies ought to do. And the reason why I mention it is because, you know, you could certainly do worse than to hone in on the things that the Commission itself says are important to it. So using plain language, making sure you have the right consent language, providing for access and portability, making sure that you have the processes in place to provide for data breach notification. If you do profiling, make sure you have the right systems in place. You're supposed to offer the applicant, for example, if you provide for loans, you're supposed to offer the applicant the right to contest the decision. It does, of course, beg the question as to why should that only be for profiling and based on automatic decision making and not for human decision making. But that's a subject for a different conversation. There are on marketing. Make sure you give people the right to opt out. Make sure you safeguard especially sensitive data such as health, race, sexual orientation, religion, political beliefs. And I'm coming back to this point, if you transfer data outside the European Union to somewhere else, usually I would assume for the majority of this of the audience on this webinar, it would be the United States, but not necessarily. You could, for example, have a lot of your business processing operations in India. But if you do, you still have to be able to explain what transfer mechanism you're using in order to do that. Well, I already talked a little bit about how enforcing the GDPR. This document provides sort of the European Commission's perspective on how it will enforce the General Data Protection Regulation. Interestingly, it doesn't really get into the question of how it will enforce against companies that maybe don't have either an office or a representative in the European Union. And that's because it is a little bit of a gray area. And so, you know, I say that not because I think, oh, that shows that if we're not physically established, we don't have a representative there, then we can blow this off. The advice I try to give companies is always, you know, be aware, do some basic things, but also don't necessarily overreact. A lot depends on the type of data that you collect, what you use it for, how sensitive the data is, those kinds of things. I just provided a slide here with the guidelines that have already come out on consent, transparency, adequacy referentials, binding corporate rules, processor binding corporate rules, personal breach notification, guidelines on automated individual decision making and profiling, data protection officers, a whole host of things. Anyway, so this is the list of what's out there right now. So now I'm going to get into a little bit of a presentation that is, in the interest of full disclosure, because I always believe in giving credit to where credit is due, is mostly based on a TrustArc webinar from about a week ago. I provided the link to that for those of you who might be interested in looking at it. But that particular presentation was interesting to me because it focused on B2B online marketing and a couple of issues that I think might be relevant to people in this audience. So if you're a publishing company and you have European subscribers and you organize events in Europe, then even if all you do is collect business email addresses and sometimes organize events in Europe, what do you need to do? What do you need to think about? So here's the link to the webinar, and it deals with, a conceptual framework, collecting and using business cards, sharing delegate lists, how to think about legitimate interest, the use of platforms in online marketing such as LinkedIn, what your opportunities might be, what technical solutions are out there. So one thing to think about, one way of thinking about this is how do you manage permission? How do you manage opt-in? What about access for your customers? There's a lot of talk, not just in this presentation, but in other presentations, about company preference centers, quote unquote. How do you allow data subjects access to your data? An ability to correct, delete, and other rights. What about collection? Have you figured out what you need? Are you collecting too much for the purpose for which you collected the data? So business cards. A lot of people ask, what can you do with business cards? And the truth of the matter is, although this is a very common issue, particularly for B2B marketers, there's no real unambiguous guidance from the Article 29 Working Party yet. But you can't assume that just because somebody gave you their business cards that means that they gave consent to receive marketing messages from you, even if the card was provided in a business context. Having said that, if you think it does constitute consent, you still have to be able to provide that individual with all the rights that data subjects have according to the General Data Protection Regulation. You still actually have to have the infrastructure, as it were, to handle access, right to be forgotten, data portability, all of those other issues. What about those of you who organize conferences in Europe? I know we do as a trade association, and I know that many people on this call, on this webinar, do so as well. Remember, you need to collect consent if you want to market to delegates. You need to do that, for example, through opt-in at the website registration stage, or maybe at the physical registration stage, or maybe through a follow-up email, but somehow you'll have to get consent. And attendees have a right to know how their data is being used. They have a right to access to their data. And one new thing, that access has to be free. You can't charge for that access. And lastly, but not leastly, you've got to be real careful with security. So don't leave physical copies of attendee lists lying around the meeting venue. There's a big debate. Those of you who attended my last webinar, remember we talked about the sort of grounds under which you're allowed to process personally identifiable information. And there's been a sort of debate about how, well, maybe the General Data Protection Regulations, Article 6, read in combination with recitals 47 and 70, will allow online marketers to argue that they can process data without consent. And that's because of this last line in recital 47, which reads as follows. The processing of personal data for direct marketing purposes may be regarded as carried out for a legitimate interest. But the may is conditional. And again, even if consent is a lawful ground for processing, I wrote that wrong, the data subject still has all the rights the General Data Protection Regulation affords. So as a practical matter, and this is not just me saying this, this is, I think, the general consensus, you will likely need consent in the vast majority of online marketing, even in the B2B context. So there's been a little bit of a conversation of what can you do in terms of B2B online marketing in platforms such as LinkedIn. Most of us use LinkedIn. The British ICO, the British Information Commissioner Office, has been asked about that. And the bottom line is LinkedIn is the data controller for all the data on the platform. But if you as a LinkedIn user use information derived from LinkedIn for marketing purposes, then you become the data controller. At least that's according to advice provided from the ICO, the British Information Commissioner Office. Now, can you market to those LinkedIn connections even if you don't have explicit consent? Probably yes, at least to your first degree connections. But it's an area that's still under evaluation, and I think a lot more guidance on that is going to be coming out in the coming months. So this all sounds, I realize, when I hear myself speak, like a huge pain, like an enormous amount of work, and of course it is. So is there any upside to all of this work and, in some cases, money that you might spend on this? Well, perhaps if you can say you're GDPR compliant, that means you're likely compliant in other jurisdictions. But more importantly, this is an opportunity to engage with your customers. But the sort of general consensus is if you do that, do it right. Don't send marketing consent requests to people who have already opted out. So you need to check that. Maybe organize repermissioning campaigns around reorganized preference centers so you can show your customers what you've done. So there is that opportunity. I mean, if done right, I mean, it's not easy, but if done right, you could maybe have a better sense for what your customers really want after you've gone through this exercise. There's a couple of, whenever we discuss GDPR, it all comes down to action items, lists of things to do. Here's one list, data flow mapping, but I would actually qualify that by saying a record of processing is something that I think a European Data Protection Authority, in most cases, would be quite happy with. And that's actually less onerous. You might have to revise your privacy notices. What are you telling data subjects regarding the use of the data? What about cookie consent solutions? Data protection impact assessments, automated systems, vendor assessments, contract reviews, advertising choices. So a whole host of things to take a look at. This is the record of processing article that I mentioned, and the reason why I mentioned that is it's worthwhile for those of you engaged in data protection to at least look at what that record of processing requires. The reason I mention that is because if you're ever subject to a Data Protection Authority investigation, the first thing that they're going to ask for is, show me your record of processing. Now again, for those companies with fewer than 250 employees, there's no obligation to have a record of processing. But actually, if you look at the requirements, it isn't so onerous. And again, there's some things in there that, that any company, no matter how large or small, has to do if, for example, it transfers PIA data from Europe to the United States or elsewhere. You have to be able to explain what transfer mechanism you're using. So I've given you, and I'm going to stop talking in about 2 minutes. I've given you all sort of a whole list of things to do, checklists, a lot of work. And there's been a lot of conversation about, why this is important, what can DPAs do, et cetera, et cetera. I think the important thing to think about is, most people don't think that either the European Commission or the European Data Protection Authorities are going to be focused on American business-to-business companies not established in the European Union. That is not going to be their first target, as it were. I think there are SIA members that are prominent social media companies that we all know. I think it's fair to say that they are going to be sort of front and center in terms of Data Protection Authority focus after GDPR enters into force. So I mean, that's, as a practical matter, going to be the case. But you might, any company needs to think about what might happen in the case of data breach, at least if you're handling data that, could have significant health and financial implications. So think about that. And again, I keep coming back to this because I have a feeling that not everybody has done their homework in this regard. Make sure you have mechanisms for dealing with cross-border data flows. For example, if you process EU personally identifiable information in the United States. So the rest of I've spoken now for 40 minutes. So the rest of the presentation is really slides from the October 3 presentation, which is just basically explains what the British Information Commission Office has in terms of a checklist. I also go through the Bavarian Data Protection Authority questionnaire. I think in the interests of letting people talk, I'm going to stop here and invite questions.
Carl, great information. Folks, if you do have questions, please go ahead and type them in under the Q&A tab in the lower left-hand corner of your screen. Carl, we do have some questions that came in while you were wrapping up the presentation. This first one might be more of a judgment call, but the question is, if we sell advertising and or sales leads to an EU company, those sales leads obviously contain contact data, which would probably fall under these rules, right? So what is the likelihood that EU companies doing business with U.S. media companies will require compliance as a prerequisite of doing business?
So the first question, if we sell advertising and or sales leads to an EU company, I mean, if those sales leads or advertising leads are for example, email addresses associated with the advertising or sales, then that contact data is personally identifiable information, which does fall under the general data protection regulations rules. If it's advertising or sales leads derived from companies in the European Union, so if you're a U.S.-based firms and you sell leads of Americans or non-EU citizens to the EU company, then then that data would not be subject to the GDPR. But the data that you collect on EU advertising and sales leads is subject to the General Data Protection Regulation. I hope I was clear on that. If not, let me know. The next question is, so what is the likelihood that EU companies doing business with US media companies will require compliance as a prerequisite of doing business? I think the likelihood is pretty high. I mean, and I'm always interested in hearing what's actually happening on the ground. So if this is happening to, one or more of you, if you want to let me know, that would be great. I think this is going to happen more and more. And actually, just to add, I mentioned earlier this New York Times article that came out yesterday on the General Data Protection Regulation, and one of the points in that article was that it sort of confirmed what I suspect, which is that the General Data Protection Regulation is having this cascade effect. So bigger companies are doing things, and then they're requiring their smaller business partners to also be GDPR compliant. And so sort of confirmed what I've heard elsewhere.
Carl, thank you. We've got another question that just came in that's pretty specific on business model. And the question is, my business model is that users can either sign up for our newsletters or go to our websites on their own and fill out either a reg wall or a white paper request. If I then take that data and run a Google AdWords or Facebook campaign to those subscribers and there are users in the EU in that campaign, how would I be able to know that beforehand? Do I have to add that as a question for the NL or the downloads?
So, what I can tell you is that this has come up in the context of what constitutes consent. So, and I know this has happened to me personally. I remember signing up for downloading white papers from a company here in the United States, and then receiving marketing advertisements from that company. Under the EU rules, merely signing up for a white paper or a newsletter does not constitute consent. So you probably would have to ask for consent. I mean, the white paper example is something that's been discussed on one or two calls that I've been in, and that's been the sort of consensus opinion. The second part of this question is, if I then take that data and run a Google AdWords or Facebook campaign to those subscribers, and there are users in the EU in that campaign, I see. There are users in the EU in that campaign. How would I be able to know that beforehand? Well, I'm not sure I completely understand the question, because the marketing goes to your subscribers. So I'm not sure. I mean, if those subscribers then forward on the marketing to other users, it's on the subscriber, not you. So I'm not sure I understand the question.
For the gentleman who posed the question, if you want to try to ask that in a different way in the Q&A tab, we'll take another shot at it. Folks, any other questions at this point? Just submit them via the Q&A tab in the lower left-hand corner of your screen. As I mentioned, you will be getting a copy of this presentation, including the links and the resources that Carl has mentioned. Okay, we don't have other questions coming in at this point. Carl, thank you very much. Sorry, here comes the question now. This is a clarification of the previous question. Retargeted ads in Google or Facebook. I cannot necessarily identify country of origin based on an email.
I'm going to have to get back to you on that. I don't know the answer to that question. But it's a very interesting question.
Okay. Folks, we will follow up on that. We are about out of time. As I mentioned, we'll be distributing an archive of this to all registrants and all attendees. Carl, terrific information. Folks, you'll have Carl's contact information on the front of the presentation, and you'll be able to reach out to him directly with any additional questions. Thanks for joining us today. Take care.
Thanks.